Hi, everyone. Welcome. So, today we are going to be talking about the U.S. immigration news and updates that you need to know so that you can stay on top of everything going on. There's some good news and some better news. And we're also going to look at the processing time that USCIS is telling us that they are processing applications on. They have historical data on how long it's taking them to process these applications. So we're going to be looking at that and talking about all the new things going on. If this is your first time joining me, I am U.S. immigration attorney Lillian Chukura, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So let's jump right in with the first good news. So USCIS during COVID automatically extended work permits. If you renewed on time before your work permit expired, you got a 540-day extension automatically. Well, they took that away last year and went back to the 180 days. Well, now they're going back again to the 540 days starting on April 8th. When you file your renewal for your work permit, it is going to get an automatic extension of 540 days if it fits into certain categories, right? You have to be filing under the same category or one of these. So refugees, asylees, A8, A10, A12, A17. They have a whole list of the ones that can be automatically extended. So if you're filing based on your asylum pending, green card pending, those are getting an automatic 540-day extension. So that is great news because we were asking for it. We've been asking for it because it worked so well during COVID that it just made sense for it to continue. So when they went back to 180 days, it just wasn't working for people because they're taking so long to process the work permits. So now going back to the 540 days makes it even easier for employers because once the work permit expires, your employer is going to be bugging you about the renewal. When are you going to have the new card? But with this extension, they are not going to bother you because it's an automatic extension. You can just print out and show that you are part of the list of people that can get the automatic extension, and your employer will leave you alone. That is great news, okay? The next thing you need to know is, so when you're filing a green card application, you need a medical exam report. And typically those only last a year to 2 years, right? The validity period, right? The time in which it's good for, right? When you do that medical exam, you want to file it with USCIS as soon as possible. And then if they take too long to process your application, more than 2 years after you send that in, you may need to do a new medical exam. Well, the new thing now is if your I-693, the medical exam report, was signed by the physician on or after November 1st, 2023, it never expires. Okay. The date is November 1st, 2023. That makes the form indefinitely good, right? You don't have to renew the medical exam. You don't have to pay again to do the medical exam. You are good to go. Once you file that with USCIS, it is good for the life of your case. So even if the case takes 2 years for them to make a decision on your I-485, you are not going to need to file a new I-693 as long as it was signed by the physician on or after November 1st, 2023. So that is great news. That will save people a lot of money, okay? That's really the big deal here because typically if USCIS takes forever, you're going to end up paying more to renew it, which means you're spending way more than you would have if they just processed your case faster. So in this situation, now that it's good indefinitely, you don't have to pay that additional fee to renew it with your physician. And then if you move, you may need to get a new physician. It's a whole thing. Now you can just know that the one you have that was signed on or after November 1st, 2023 is good for the life of your case. You don't need a new one. And then the next update is for people that have a pending U visa, T visa, or VAWA application. So typically, if you want to get an update on your case and you are filing under one of these three, there's only two ways that you can get an update. You can either mail a request for an update, or you can go to a USCIS office to ask them for an update. Those were the only ways. And then as attorneys, we have an email that we can use to ask for an update. We cannot call USCIS to get an update. You could not call USCIS to get an update. But now they have updated their procedure so that you can actually call USCIS if you have a UT or VAWA case. But they're going to ask you more questions to verify your identity than they would if you had just a adjustment of status pending. This is good to know because remember, a U visa, a T visa, and a VAWA have a confidentiality clause that USCIS is not allowed, is prohibited from giving your information to anyone, especially your abuser, especially the person that committed the crime against you or the person that trafficked you. So now you don't have to go the extra step of mailing a request, waiting for that mail to get there, all of that, or scheduling an appointment with USCIS office to go there and get an update. You can just call, but be ready to answer those enhanced identity verification questions. If for some reason they're not able to verify your identity with those enhanced questions, they will have you schedule an appointment and go to a local USCIS office to verify your identity and then to get that update that you're looking for. Okay. So this is a good thing. Okay. This gives you more access, more ways to get updates on your case that's going to be easier for you. Okay, this creates less obstacles, especially for these cases where people are already going through so much. USCIS is trying to find ways to ease the process, right? Make the process much, much easier for them. So this is a great thing. You can call USCIS now and just verify your identity and you'll be able to get that update or request, do a service request on your case. All right. So if you have any questions, feel free to put them in the comments. If you are getting value out of this video so far, go ahead and hit that like button for me. All right, so the next thing is, I think you all, if you've been watching my videos, you already know this, but the new fees are officially in effect. So if you didn't know this, I have a whole video where I break down the fees and what they're going to be starting April 1st. They are officially the fees, okay? They're not prospective fees. They're now the fees. So you need to make sure that when you are filing your applications, that you are filing with the right fees, okay? Please, do not file with the wrong fees because guess what? It will be rejected and you'll have to do it all over again, all right? Remember that some forms, right, some fees are going to be automatically waived if it's based on U visa, T visa, VAWA, asylum. Okay, so you want to make sure that if you're filing, let's say, a green card application or a work permit based on VAWA application, that you are not including a fee because guess what? That fee will be rejected and your entire application may be rejected as well, and you'll have to send it in all over again. So make sure that you are taking a look at the fees and using the right fees. USCIS has a fee calculator. So if you're confused, right, if you're confused on which fees you need to include, how much you need to include, please use the fee calculator. Some forms will have a different fee if you file online and a different fee if you file on paper. So typically it's a $50 difference between filing online and filing on paper. Not every form can be filed online. Okay, not every form can be filed online. So make sure that you are filing on paper if that's the only way you can file. If you can file online, then you can file online and get that $50 discount. USCIS did that on purpose because they want you to have an online account. They want you to file things digitally because they are trying to go digital, right? They don't want paper. But they haven't been able to put all the forms online. So the ones that they have, they want you to use the online account because guess what? When you send it in on paper, they still have to scan it and turn it digital. So they want to skip that step by having you file online. So just make sure that you are filing online when you can. If you can't, it's perfectly fine. Just know you may have to pay that extra $50. And then just also know for citizenship applications, if you do not qualify for a full fee waiver, you may qualify for a reduced fee. So USCIS is now accepting reduced fees. They will have to look at your household size, your household income to determine if you qualify for that reduced fee. Okay. If you do qualify for the reduced fee, you'll get to pay less than everyone else. Okay, so make sure that if you know that your household income qualifies you for the reduced fee, that you are filling that section out on the citizenship application so that you're paying a reduced fee and still getting the same service. All right. So I see a question here. Okay. I just created a joint bank account with my USA spouse. How long should we run the account before we use it for the application? Um, there's no how long, because even if you include it with your application, now USCIS is most likely going to ask you for additional documents or schedule you for an interview. At the time of the interview, you'll need to take updated statements with you. So it's up to you how long you want to wait. There's no waiting period that you need. Just know that when USCIS officers are reviewing your file, they may ask you for additional documentation. Then you can supplement with months of those bank statements. Or if you're scheduled for an interview months down the line, you can also bring those additional bank statements. But there's no specific period of time. It's just, what do you feel comfortable with? All right. Okay, so the next thing I wanted to cover, as far as news are concerned, is the new gender option when you are filling out USCIS forms. So now there is 3 gender options. So you can do male, female, or other, and that will be marked as an X depending on what document you're receiving. So if it's a document that has the gender actually on it, it will just be marked as an X. But that is a new process that USCIS has put in place. On the forms now, they have updated all their forms that ask for your gender to have that additional category. So make sure if you do fit into a different gender that is not male or female, that you are now able to select that. Even if you are applying for a US passport, you can select that as well. So make sure that you are selecting the right gender that properly reflects your gender identity. All right. So great question from Instagram. Any updates on waiting time for I-130 foreign spouses? Wow, you are ahead of me because that's the next thing I want to talk about is the processing time that USCIS recently released. And according to them, that's all I'm going to say. According to USCIS, the I-130s are taking about 11 months. If that is not your reality, let me explain to you why and how they can get to the 11 months. So USCIS basically takes all the service centers that processes I-130s and puts them together. All the different categories of I-130s, puts those together, and then takes the average. So your case may have taken a year and, or more, but someone's may have taken 2 months. Guess what? They're going to count that and take the average. So even though they're saying 11 months, typically you want to look at your service center. Okay. On your I-130, there is a service center. You want to look specifically at how long is it taking at that service center. Recently, California is taking the longest. They basically just threw up a number. It could take more than that. It could take less than that. But in our office, we are seeing between a year and a year and a half. Okay. So if you're still well within that time frame, just know it is normal. Okay. Don't believe the 11 months. It is an average of every single I-130 that is filed. It does not mean that every single I-130 is decided in 11 months. But like I said, you want to find your service center, which will be on your receipt notice. On the very bottom of your receipt notice, it will have the service center, and you can use that to look at the processing time specific to that service center. Okay. Remember, they're just using an average of all the service centers, and you want to know specifically for yourself where your case is, what that processing time is. Okay. So that leads me to the next thing that I want to talk about, which is the new processing time fact sheet that USCIS put out, that they're telling us this is how we're processing cases, right? And it's a historical document, right? It's showing from 2016 to now, basically. How long is it taking them? And we're going to get into that. Let me just answer a couple more questions. All right. So, Euphoria is asking, hi, I just got on. What are you talking about? Hi, we are talking about U.S. immigration updates, like the automatic extension for work permits, the I-693, the medical exam report being good forever. As long as it was signed by the physician on or after November 1st, 2023, that UT and VAWA applicants can now call USCIS and get updates on their case, while before they had to send mail or physically go to a USCIS office to do that. And that the new fees are now in effect, and you want to make sure that you are putting in the new fees, or you're going to end up having to redo the process of sending the application to USCIS. And there's now a third gender option on USCIS forms. So female, male, or other. And on documents that have those additional, that actually show gender, it will mark that third gender as X. All right. All right. So I will get to more of your questions, but I do want to cover the new fact sheet on the processing times, because we were just talking about that. All right. So the thing about this, and I want you all to really pay attention to how USCIS is looking at these things. Okay, they're not looking at it as just a singular thing. They're not just looking at one specific category. They're looking at things broadly when they're talking about the processing time. So the I-130, which we were just talking about, right? That immediate relative petition, it does not say I-130 based on marriage, I-130 based on parent-child relationship, right? It doesn't say I-130 based on the different categories that you can file an I-130 under. It is very broad. So when you're looking at this, please know that this is an average of the whole category of I-130s, okay? All right, so let's break this down. Based on a pending asylum application, if you're filing a work permit based on a pending asylum application, they are saying in 2024, they are currently at 6 months. That's great. That is great because, listen, last year it was a year and 6 months. Yeah, it was way before that. So we really want to, so these are broken down into months. So they're trying to, listen, they're trying to say it's taking less than a month. I don't think so. Right. I do not believe that it's taken less than a month because we haven't been seeing it taking less than a month. It's more within a month, right? It's less than like a month and a half for most people, unless, let's be clear, most of them will be close unless you get a request for evidence or you didn't include something that is required for you to get this status. Okay, so it's really important that's why I always preach that when you are filing an application, whether it's a work permit, a travel permit, green card application, I-130, that you are really, really sure that one, you qualify, and two, that you are including all the information that's required, and three, that you're including all the documentation that is required. Because if you do not include one of these things, it's going to slow down your case and they're going to send you a request for evidence that you then have to send back to them. It will delay your case. So for this, yes, for most cases, it may take less than a month, but if you have a request for evidence that goes out to you, it's going to take more than a month. Okay, so you kind of get to control how long some of these things take by making sure that what you're sending in is complete and exactly what USCIS is asking for. Okay, if it's not what they're asking for, you may end up not having, not being within this processing time. All right, so the ones based on adjustment of status is taking 3.6 months. Yeah, that's the tip. That's what we've been seeing lately. Those are taking less time than they used to. So before I used to tell people 6 to 8 months. Now I tell them 6 to 8 months, but it's probably going to be way less than that. The ones that are taking more than the 3.6 months is the ones that they are approving the parole at the same time. Okay, if they are approving the parole at the same time, it's going to take a bit longer, but you end up with one card that has both the work permit and the travel permit on it. But if you are filing, if they are approving those separately, the work permit will definitely come in faster than the travel permit. All right. Based on parole, less than a month. I can attest to this. Those are taking a shorter period of time. Again, these are all based on certain things being done correctly, right? If you have a biometrics appointment, making sure that you actually go on the date that you're scheduled so that you don't delay your case. Okay. So there's things you can do on your end to fit within this processing time. All right. All other applications that are not based on asylum, a parole, or a pending adjustment of status application, a pending green card application, is taking about 2.9 months. Okay, so closer to 3 months to be approved. If you are applying to request or to re-register for TPS, those are taking 8.7 months. Okay, so if you have a TPS application pending and you're wondering, why is this taking so long? It's been like 6 months. Well, now you know. It's taking 8 months on average. Remember, these are averages. So that means some may take less and some may take more time, but the average is 8.7 months. If you're applying for asylum, if you're applying for asylum based on, if you're applying for a green card based on asylum, right? Sorry, y'all. If you're applying for a green card based on asylum, it is taking 30.9 months. We have a few pending that's been more than 13.9 months. But again, that's why I want you all to remember, this is average, right? This is average. This is not every single person's application is going to be approved within this time. This is kind of like USCIS saying, this is what we want, right? This is the processing time we would like to stick to, but does it happen? Not really. All right. If you're filing for green card on refugee status, 13.3 months. So it's very close to the ones based on asylum. If you are filing based on employment, then those are taking 7.2. See how that's faster. Family based is 9.4. Now, I can tell you, this is pretty accurate, right? Some of these I'm like, but this is pretty accurate. If there's no issue with your case, USCIS typically has been trying to schedule those interviews quicker or make a decision on the case, okay? So typically within 10 months, they are sending you either a request for evidence or an interview notice. They've been really good with that lately. So just know, again, this is the average. Okay, so yours may take longer or may take less time. I've had some that had an interview within 4 months of filing. Okay, so it's not, so that's why when I say this is an average, it is an average. Don't think that your case, there's something wrong with your case if it's taking more than the time that they put here. Okay, if your case is taking more than 9.4 months, do not freak out. Okay, do not freak out. What you need to do is go on the processing time website, right? USCIS processing time. Put in your local USCIS office, your field office, and see how much time they're taking to process those applications, because you may find that it is not 9.4 months. Okay, so before you freak out on any of these and you're looking at it and you're just like, but my case is taking longer than that. Think about it. This is an average. So you want to go and look at the processing time for your specific field office so that you know how long is this actually taking where I live. Because in some places, it may be taking 3 months, right? In some places where there's less population and there's only like a few people applying for adjustment of status in that area, it's going to take them, it's going to be faster. But in density, like let's say New York, it's going to take longer because there's more people applying and you are just going to, you might take longer. So you always want to check your processing time based on your local field office. If you do not know where your local field office is, go on the USCIS website, search for field office, and there's a place where you can put your zip code and it will tell you exactly where your local field office is located. And that way, when you're looking at the processing time, you are looking at the right place, okay? For immediate relatives of U.S. citizens that have an I-130 pending, they're saying those are taking 11 months. pretty accurate. It could take more than that. If there's any request for evidence, it's going to take more than 11 months. It is, but the average we're seeing is between a year to a year and a half, even with the request for evidence. So it's really important that you, again, check your service center, because these are filed with service center and not the field office. Okay. So just be aware of that. And you can find your service center on your receipt notice on the bottom left-hand side. It will have the service center written there. And that way you can look at that processing time and get the right location. All right. Next up is application for naturalization. This is one of the ones that USCIS is very proud of, okay? Along with the work permits that they are now processing less than a month or at a month, they are really proud of their naturalization, the N400, because they used to be, as you can see, in 2020, it was 9.1 months. 2019 was 10 months. 2021 was 11 and a half months. 2022 was 10.5 months. 2023 was 6 months. That was a huge drop, right? And then now we are at 5.2 months. And I can tell you, this is really accurate, okay? They are working overtime on these because they want to get these numbers down as much as possible, especially with the citizenship application. So if you are filing for citizenship, be ready, right? Study. That's why I tell my clients, if you're filing for citizenship, please make sure you're studying, make sure you're ready for the interview, because you may be getting it sooner than you expect, okay? You may be getting it sooner than you expect. So it's really important that you are, you know the requirements and you're ready to go before you file, because 5.2 months goes by fast. And in some areas, especially where my office is located, most of our hours is taking less than that to get an interview. So it's really important that we know which applications that they are really putting energy behind to get the processing time down. And the naturalization is one of the ones that they are really pushing to get down. The next one is the advanced parole document. They are saying 4.4 months. This is one of the ones I can tell you it's going to take more than 4.4 months unless you have, unless you're also filing an expedite request, then it will be shorter time, but these are taking longer than that time. So when I say an average, it's an average. It is taking longer than that. So you want to be prepared that if you know you want to travel at some point, even if you're applying for a green card or you're applying through TPS, once you get that TPS, once you have your, once you're applying for your green card, that you're also including that travel permit application so that you are able to get that sooner rather than later. Because if you don't apply for it and then something happens and now you really want to travel without that document, you're not going anywhere. Okay. Without that document, you're not going anywhere. So you want to make sure that you have, that you're applying for that if you think you may need to travel. The parole in place is for people that have family members in the military, immediate relatives of military members may be able to apply for parole in place. This is if they entered without authorization. So they entered through the border, they didn't have a visa, they didn't have parole, they can get parole in the US and be able to adjust their status through that US citizen child. And those are taking 4.8 months. Travel documents, this is typically for asylees or refugees. Those are taking 15.5 months. Yeah, 15.5 months. That is a long time. Look at this. In 2018, it was taking 2.9 months. 2019, 2.8, 2020, 4 months. 2021, 7.2. 2022, 10.6. 2023, we jumped up to 15.9, and now we're at 15.5. That is taking a very long time because someone that is a refugee or someone that has asylum cannot travel unless they have a travel document. Okay. This is not like permission to leave the US. This is permission. This takes the place of a passport. Okay. A travel document takes the place of a passport because usually refugees and asylum seekers that are approved for asylum do not turn around and apply for a passport from the country that they were seeking asylum from or refuge from. So they would need a travel document to be able to travel outside of the US. They can always come back, but to travel to other countries without a passport, they need a travel document. So this taking 15 and a half months is pretty accurate. It is taking some time, and hopefully those come down. But for right now, that's what it is. And then the I-90, this is for replacement or renewal of your green card. Those are taking 3.3 months for some. Like I said, this is an average. This is an average. I have had ones that were approved in like a month. I will tell you that, but I've had some that have been pending for a year. So it just depends on where it lands. So you always, again, want to check the processing time of where your application landed. And then for non-immigrant petitions, this is for employment-based mostly. Those are taking 2.7 months. Now, they are the employment-based, the I-129s can also do premium processing on top of the fact that their applications take way less time to be processed, way less than the I-130 for immediate relatives of US citizens, mind you. They also get the option to do premium processing, which will even drop that number down to like 2 weeks. So 2.7 months, pretty accurate. But if they also do the premium processing, it's more like 2 weeks. So if only they would do that for immediate relatives of US citizens and cut that number down from average of 11 to 2.7, right? So this is what they're telling us, right? We can see what it was in 2016 versus 2024. Right? Some of these went down, some of these went way up. Especially again, immediate relatives of US citizens are my heart, right? They just want their families here. They just want to bring their families. They just want to be together. And it went from 2016, 4.9 months to 11 months now. So, and it's been gradually increasing every single year, right? So it wasn't that COVID caused the increase. It's that it's been gradually increasing and now we're here. So talk to your Congress people. That's all I can tell people. Talk to your Congress people because they can have more capacity, more funding, things like that, to make these go faster. All right. So these are the processing times they decided to share with us so that we can see how they're doing. And hopefully they keep sharing these with us so that we can see where they are. Okay. We want to see where are they, how long are things taking on average so that we can kind of hold them accountable. Like if they come back next year and telling us that, it went from 11 months for immediate relatives of US citizens, I-130s to 15 months, we want to understand that, right? Because the fees increased. So we expect more efficiency from USCIS when they increase their fees. It just makes sense. It's business, right? Business 101. If you're going to increase fees, you should be providing a benefit that is worth it to people. All right. So if you have questions, put them in the comments. I will be responding to them. I see a few. Okay. Let's see. Hi, can you guarantee me a work permit from a VAWA case if I hire you? First, I have to decide that you have a valid VAWA case. And if you do, we have to figure out if your spouse is a US citizen or a permanent resident. If your spouse is a permanent resident, there is no visa immediately available, so we cannot apply for the green card application. So in those situations, I cannot guarantee you a work permit because you wouldn't qualify for a work permit yet if the spouse is not a US citizen. Because again, spouses of US citizens are immediate relatives. So there's always a visa available for them to apply for a green card. And the work permit is through that green card application. Okay, not just the VAWA application itself. And if your spouse is a permanent resident, you have to wait for a visa to become available before you can apply for the green card application. And with that green card application, you can then apply for a work permit. So it just depends. Okay. Can I guarantee it? If you have a solid VAWA case and your spouse is a US citizen, yeah, you can get a work permit if you're applying for a green card at the same time. And with the new fees, you don't even have to pay for the work permit or the green card application. So that's also something to keep in mind. All right. Nee asks, my case was documentarily qualified last August. Since then, nothing has been heard from the MVC. All right. So this is a big problem right now. So the MVC, unfortunately, does not control the dates for the interview. So the next thing that happens after you are DQ'd is that you get an interview. That's the next thing. The MVC at this point, once they DQ you, are just waiting for the embassy to tell them what date they can schedule you for the interview. They do not control that. So if they are not communicating with you, is because the embassy has not communicated with them about an interview date. Okay. So depending on the country, right? Each country has their own time frame. Depending on the country, it may take a year, it may take a few months. So you need to know what country, what is the typical time frame that is taken to get that interview. Most places some places it's taken like a couple months. And then other places it's taken a year to a year and a half just to get an interview. And then other places are not even scheduling interviews out right now. So it's really important that you know that it's the embassy, not MVC. Okay. So each embassy has their own timeline, and you want to make sure that you're following those timelines. You also want to look at whether you have a reason for your case to be expedited. If you meet one of the expedite requirements, you want to go ahead and send that expedite request to the MVC. They will forward it to the embassy, and the embassy will make the final decision of whether to expedite your case, which is basically get you a date ahead of everyone else. And those typically need a very strong reason to do that. Okay. You need to have a very strong reason for them to move your case above everyone else's that's been waiting before you. All right. Next question. I filed for an I751 based on cruelty for over a year now. I called USCIS to check my case, but they said they don't see anything on my case. Do you know why that is? Mostly. Okay. Let me say this. If you call them before their new process, you're not going to get an update. So I-751s based on cruelty are handled similar to VAWA applications. Okay, there is a lot of confidentiality involved in order for USCIS customer service to be able to give you an update. All right. So before they put this new enhanced identity verification in place, you would not have to, they wouldn't even see that there's a case there. All right. Because they're not able to verify your identity. Now that they have this enhanced identity verification process, you probably are now able to go through that enhanced verification, and then they will be able to see that information and give you an update on your case. But yes, when it comes to I-751 based on cruelty, it is treated like a VAWA case where there's the highest level of confidentiality. And now, I think starting next week, I will say wait till Monday so that they figure out their process, right? But call again and go through that enhanced verification so that they will be able to give you better information. But yeah, before they did that, you would need to go ahead and mail your request for an update, not call. It's weird because it's a 751. So you think that it's going to be the same process as any other 751, because if someone that filed based on filed jointly with your spouse, they can call and get that update quite easily. But because of that cruelty, it's now in the same confidentiality as a VAWA application. All right. So, all right. If you have any other questions, please go ahead and put them in the comments. Perfect. All right. About 90 days visiting visa. I'm trying to bring a friend over from Zambia. Well, your friend has to show that they qualify for a visiting visa. So even though you may be filing an invitation for them, right? If you're filing an invitation, it does not mean that the person qualifies. So you may send an invitation letter saying that you're going to pay for everything, they're going to stay with you, all of that. You can say all of that. But guess what? USCIS still, I'm sorry, the embassy still has to approve the person, right? They still have to show that they plan on going back, and they have so much going on with them in their home country that they have no intentions of staying in the US, right? Unless something drastically changes. That they have employment, they have family, they have a business, they are involved in government, whatever it is that they have going on, they have to show that in order for USCIS, for the embassy. I keep saying USCIS because that's who I deal with every single day. But in order for the embassy to approve their visiting visa, they have to show that they qualify. Your invitation is only like 1% of the process, right? If the person wants to go to Disneyland, they don't need an invitation. They can just buy their tickets and their hotel and all of that and ask for a visa to go to Disneyland for vacation. So they don't need you to do that process. So that's why I say that the invitation is not that important, because there's other reasons that someone may want to come to the US that does not involve seeing a friend or seeing a family member. But what is important and what everyone has to show is that they have things going on for them, that they will not be staying in the US. And that's the hardest part for people. That's the hardest thing to show, because how do you show that you have no intentions of staying in the US unless you have money, unless you have the resources or the family ties that's holding you in your home country? So I hope that I always like answering those questions, because it is one of those things that people always want to do, and they think it's all about the invitation, but it is really less about the person in the US and way more about the person outside of the US. All right, next question. How long should I expect this case to be adjusted for my I-751? At least if you've been waiting a year, give it another year to 2 years. And I know that does not sound good. Okay. Don't even, I know that does not sound good, but that's the typical time frame right now. A minimum of 2 years that we're seeing. If you qualify for citizenship, you can apply for citizenship, and that typically will make it go faster. But that is the normal. Waiting like 2-3 years for that is pretty normal. That's why they send you that receipt notice with 48 months, 4 years extension. There's a reason they send that out, because they know that they are not really prioritizing the I-751s. So they're giving you a 4-year extension. Please keep this. You can travel, you can work, you can do everything. Let us take our time and process these applications. So what we typically do sometimes is, if the person qualifies for citizenship, we may apply for citizenship just to um, you know, two birds, one stone. You can get the I-751 and the citizenship approved on the same day. All right. So you go from I-751 approval to citizenship approved on the same day. So sometimes that's what we do. Oh, okay. That goes into that. If one gets their I-751 approved based on cruelty, can one apply for citizenship within 3 years of having the green card? The answer is yes. Okay, the answer is yes. You can still apply within that 3 years. Funny enough, USCIS updated their N400, and now there's a space for VAWA. So people that get their green card through VAWA, there's now a space where you can check off that that's the basis, and you can still apply within that 3 years. So yes, 3 years applies, even if it's a 751, as long as it's through the battery and cruelty clause. If it's divorce, no. If it's joint filing, yes. If it's cruelty, yes. Okay. Perfect. Um, any other questions for me today? And I'm so glad that you guys are getting value out of this. Remember, if you are getting value out of this video, if you're um, getting the information you need, go ahead and hit the like button. Just let me know that you are getting this information and liking what you're hearing. And Nee, you are very welcome. I am always happy to answer your questions. So go ahead and put that in. All right. And Mr. Toss, listen, thank you. Thank you for saying that. I am, again, very happy to help. And, one thing I know is, when me and my family were going through the immigration process, there was no one to ask questions. We were basically going through it blind, and being able to give information to people and help people. It's kind of my goal with these videos. Okay. What do I need to apply for my kids who have been in the USA with me when I'm a citizen? As long as they entered with a visa and are under 21, you can file for them just like an immediate relative of a US citizen, right? So I-130, I-485, all the other things in between, that's what you would need, okay? So once you're a citizen, you can file all of those. And since they weren't included in your green card, since they didn't get a green card at the same time as you do have to wait till you're a citizen to do that. And just make sure that you are okay. Yes, they're under 21. Perfect. So they will just be considered an immediate relative of a U.S. citizen, and you can file for them with the typical forms, like I said, the I-130 and all of that. All right. And just make sure, because people always forget this. I know they're children, and I know they probably have no intentions of working, or you have no intentions of your children working, but do include a work permit just so they can get that social security number. Okay. I know it doesn't, like for most people, it doesn't matter, but go ahead and get that for them. If they're 16 and, want to get a permit, having that work permit will actually make it possible for them to get their learner's permit and then get their license while the green card application is pending. So it's one of those things that parents kind of overlook because they're like, oh, they're a kid, we can just apply for the green card. Just go ahead and spend the extra $260 and get them the work permit so that they have that document, so that whatever they need to do, whether it's getting a license, whether it's applying for college, whatever it is, they have a social security number to go along with that. All right. Okay. So, great question. Love this. Great question. If your children are under 18 when you become a citizen and they have a permanent residency, then yes, you will file an N600 for them. But if they do not already have permanent residency, they need to have permanent residency first. Okay. So let's say they are 14 and you become a citizen, you can file, and they don't have a permanent residency, you can get them the permanent residency. And once they have that, they can automatically become citizens as long as, again, it's under, they were under 18 when they got that permanent residency and when you get your citizenship. So if they're already a permanent resident, you just have to become a citizen, and they need to be under 18 when you become a citizen. And you also have to show that they live with you, right? That you have custody, physical and legal custody of them to do the N600. But yes, if they already have it, then you can do the N600. But if they do not, your first step is the N600, okay? So keep that in mind as you are kind of thinking and doing the math on when you can do certain things. Just know there's just sequence to the N600, and you want to make sure that you are following that sequence to make sure that you're not applying for anything too early as well. All right. Thank you all so much for joining me. And remember, if you need help with your immigration process, you can always schedule a strategy session with me by going to my website, lilylegal.com, or calling my office at 508-443-1788. Thank you all so much. And I hope you have a great rest of your day and a wonderful weekend. Bye. Oh, and the best contact to reach me at is either calling my office at 508-443-1788 or scheduling a strategy session right on my website on the contact us page. You can book a time that works best for you. You can see my calendar and see when I'm available, and book that time, and then we can chat. And you can also email at lillian@lilylegal.com. Thank you all. Bye.